measure will be lower than if you are processing DNA or other kind of data. Then you need to reflect on what kind of data intends to process and then introduce the appropriate measure. Define the access, to whom I want to give access and to what the condition for providing access. How can I check that the right of access is not abused by the person to whom I'm granting access, and then the logs, the logs and the analysis tools which allows to go into the log system allows the controller to be able to understand if something wrong is going there. Other principles which are of particular importance is if the controller is not processing the data directly, but they are using other person or companies the controller has to choose a processor which ensures adequate security and adequate possibility to keep the data under control. This is particularly relevant, for example, in the debate on the data retention of traffic data. We have different fields where this principle of stringent actuality, so to say, that not just a virtual way of dealing with questions which are far from us. So fundamental data protection is a fundamental right, of every individual. We are included in that dimension, so we need to have our data protected and keep control of our data as far as possible. The restriction of our control and our right are only possible if the public interest is to be fulfilled. So in the interest of the entire collectivity. That's why we are dealing with this matter here. But notwithstanding this, there is a need to proceed following rules, and the rules are good sense rules in the large majority. So they are just saying, you are treating things which represent a value, which represent sometimes a fundamental value of the person. If you deprive that person of their rights, that person will be in big troubles. So be careful with this. Take care of the right legal framework is in place, the right reasoning on the use of the data, and the need to know, the need to keep the data, and to what extent for how many years you really need it. This is part of a cultural approach. We can call it privacy by design, privacy by default, general principle of processing of data, but is substantially part of our lives. We always manage this. And so coming back to the Garante has a certain kind of powers towards the checking compliance with processing of data, also in the judicial sector, and tries to help in making the appropriate laws or regulation. So it is normally consulted by the Ministry of Justice, and it has provided opinion in several occasions on this, on the point I've mentioned before. So in the use of IT tools for public auction, in introducing information and communication technologies in civil and criminal proceedings, rules and functioning of the Judicial Records Office and access to records by public authorities and other authorized entities, and the use of IT tools in civil proceedings, so to mention some. And then another area where the Garante is active is in regulate the processing of sensitive data in this field. And so it has helped the Ministry of Justice also in regulating the use of sensitive data and put this regulation update Then what to say? Just a few words on the new legal framework. You know that our law, coming back from an attempt to harmonize data protection principles, but this attempt is not complete in the sense that each member state has transposed the law on the basis of its culture and its perception of the main priorities. So the next step in the package proposed in 2012 by the Commission is to have one single rule, the regulation for the general data processing, and then have a directive for the processing of data in the criminal and environment, police and penal justice. This process is ongoing. There are discussions in the DAPIX. The Italian presidency, which is represented by the Ministry of Justice, is trying to achieve a sort of common understanding on the main parts of the regulation. They have succeeded on Chapter 4, which is on the obligation of controllers, and now is trying to achieve major results on horizontal questions like the risk-based approach, the possible flexibility for public sector, the need for specific provision in certain situations like the freedom of expression, health, etc. So this is the aim of the Italian presidency, and we hope that the Italian presidency will be able to succeed in this. As for the directive is not so high priority in the discussion, but it goes more or less on the same level, so it can take profit of the general approach in the regulation for some part of the directive. So thank you very much. This is my presentation. Thank you.
Thank you very much. Before giving the floor to questions to the public, I myself would have some questions to our speakers. To the EDPS representative, I would like to have a question concerning your opinion on the Commission data protection decision related to e-justice. And your opinion related to this decision, that you are suggesting that there should be a stable legal basis on e-justice, but it has to be noted that in several points of the e-justice action plan, we already have specific legal bases in regulations or directive. So is the case for the translators databases, is the case for small claims and European order for payment procedures, for arrest warrant, and we are just negotiating the insolvency regulations. So possibly it's only the land registers interconnection for which we don't have a specific legal basis. So what can the special e-justice regulation contain?
Thank you for the interesting question. It is not an easy question, and I think in any answering this, there has to be a balance between two things. On one hand, it is very important to have legal certainty about what data is processed, or what individuals just have to know what is happening to their data. On the other hand, there has to be some flexibility for the persons, for the Commission and member states who want to run their projects in the most appropriate way, some flexibility to change their minds, to do it differently. So these are inevitably there will be tensions between these two, but it's not something that there's a tension only in the field of e-government, of e-justice. Any legislation has to be balancing flexibility and legal certainty, and this is the same case here. So we as EDPS have been quite patient with the Commission so far, so we were happy that there has been a step-by-step approach, that we are happy that there has been this year or recently this Commission decision, which is already raising transparency a bit higher level and legal certainty. So it's a bit more clear of what the Justice Project means. But we are waiting for a more stronger legal framework, and I'm hoping that the new Commission will share this need for the new legal framework. It's not the first time that we are asking for a regulation. We have done this with some of you may be familiar with the Internet Market Information System. That was also that's also a system that we actually quite like. It's very well designed. It's a good privacy by design. Privacy is built into the system in many different ways, and we had a good working relationship with the Commission, but it took years and years and years to actually have a regulation on the Internet Market Information System, and it took an extra couple of years until there's a supervision by data protection authorities, which has just, the first meeting was this year. So things don't happen overnight, and we understand that it takes time and there's a need for flexibility, but in the end we would like to see a stronger legal basis.
And thank you very much. And another question relates to the presentation of our Italian colleague, and also to the EDPS presentation. How is the purpose limitation principle respected if the data are coming from other sources? So if the data are collected for the purposes of giving information, for example, on cross-border proceedings, so on cross-border insolvencies as an example, but the data are coming from a national register, and in the national register, all the procedures are contained, information on all the procedures, not only the cross-border ones.
I'll try to answer to you. Then the purpose of the processing must be clear. You say, I need for insolvency procedure. So you need to have a legal base for this, and you need to have a provision say that to that end you can receive data coming from public registers or other things which are linked to this insolvency. So you need to cover the possibility to receive data or to send data as a member state. I refer to a member states. I can refer to, for example, to the activity of Europol, which I know maybe better, and they have specific provision. Europol has purpose limitation in the sense that the scope of Europol activity is fixed in a norm. So then the rules say exactly which is the scope of the activity in Europol. So Europol can only do what the law allows them to do. And then in order to perform the institutional task conferred to it, Europol can receive or send data, but for receiving or sending data, specific provisions are to be introduced in order to clarify in which cases and given the appropriate legal base to this activity. So it is not possible just to receive data from whatever sources and integrate into the dossier, since then the output would be something which is not covered by the legal basis and can be counterproductive for the activity, in terms that you cannot control the output. You can base your processing of data of your activity in the insolvency proceeding on data which are not exact, which are not updated, which are false, or or something like this. So you need to assess the source, you need to assess the quality, and then the other things comes. But I'm not sure to have answered all your question.
My question was also a bit of a technical nature, how you distinguish the data that are collected at national level, but for the cross-border information, you only need some of them.
You need to collect data for the same purpose, and then you can send the data for the same purpose. So there must be a link. A link is provided by the purpose of the collection.
I have to admit, I'm not familiar with the details of the insolvency interconnection, so I don't know exactly which are the data fields that would be, that would be necessary to share at the European level, and which ones just for national purposes, or whether it's the same. But in any event, from our perspective, what's important is that those who are actually building the system would very carefully think through what is the data available in national systems, compare it what's available in Austria, what's available in Italy, different countries, see if there's really a need for to share that internationally, I mean international meaning between the European Union, data by data, really very carefully, and not to do more than necessary. For me, it is will come with this saying that yes, it's necessary all across, and it's fine to share everything for the same purpose as it was originally collected. But then it also has to be very carefully actually the purpose of an insolvency register, who can use it. Could it be, for example, used by some marketing companies who are trying to give loans of credit to insolvent companies, or sort of credit sharks, for example? Is it possible? Is it not possible? Maybe it's possible in one country, maybe it isn't in another. Probably I would hope it's not possible in most countries. But these things have to be, that's what purpose limitation is about. It has to be thought through. And once it's taken to European level, from national level, it's going to be more complicated, because you have to come with a common solution.
Why is a specific European instrument necessary? Because from the example you elaborated on in the second phase, to me, it's clear that such a common instrument might also be restrictive. Because for every functionality within e-justice, you might need a different approach. And therefore, as stated by Nora, there is, in some cases at least, there is already a specific instrument. So if you're trying to make also a common instrument, you might run the risk that they are in contradiction to each other. And also that when a new functionality arises, that it is not covered by the common instrument.
Thank you for the question. I think it's a very fair question. And as I said, it's not, we don't have the silver bullet for everything. So it's also possible that we are wrong. That's why, I mean, that's not because we think we are wrong. That's why we are not so stressing so much the Commission to go through with this. But we do think that it would add value and it would be useful. And the reason, maybe it's helpful if I give you the example of what happened. I know it's a different system, but what we have done with the internal market information system. In some ways, that is similar to the project itself, to the e-justice project, in that it has started relatively small, and it's growing, and it's quite ambitious, just as I hope the e-justice project will also be growing and be quite ambitious. And in the beginning, there were Commission decisions, there were low-level sort of legal framework for it. Then there were some not horizontal legal instrument covering the whole system, but of some area, like, for example, in that case, it would be the services directive, like exchange under that directive of personal data, then the professional qualifications directive. Just the same case as here, there would be, for example, the insolvency register would be one thing, later maybe the real estate registers would be another thing. It is very important that there would be these sort of, let's call it sectoral legislation, like that's it, insolvency register would be in place, or at least almost in place, like it is now. That gives a legal basis for it, so that actually makes it possible, makes it legal under the data protection rules to share data. So that's really important. But where horizontal regulation could add value is to provide the rules that are more transparency and more certainty on things that are common. It would be at one place, there would be a set of rules applicable to all systems, and which could give also an overview and maybe sometimes limits to what the Commission could do, or the member states. For example, in the IMI, Internal Market Information System, it cannot just from day one, without the Parliament and the Council being involved, cannot just say that now IMI will be used also for criminal information exchange. That would be a bit overboard. Whereas if there hadn't been an IMI system, there could be a new directive, and it just would streamline make it more legal. It would increase legal certainty, and it would increase transparency. That's the main issue, but from our perspective, data protection, but it wouldn't be unuseful for the e-justice project itself more broadly also, because it would help raise the profile of it. So it would give it publicity. It would could sort of consolidate financing also for it, because it could provide for a financing background. So there could be other advantages as well of making a regulation. But as I said, we are not the lawmakers. We are advising. We say what we think. You say what you think.
And are there any other questions also to the other speakers?
I have a question to Aki. It's one of the most, your presentation was very interesting. Let me state that first. And the rules are quite complicated, and you're going through them quite fast. But I was thinking about one of the most famous cases, I think, from the European Court of Human Rights, and that's Finland versus Z. And that's a decision from 1997. And one of the things that struck me most in that judgment was the fact that in Finland, clearly it's possible to have access to the documents of a criminal case after a certain period of time. So after the judgment has been rendered, let's say 10 years or 20 years later, the public has access to the case files. And that was one of the underlying problems in this judgment. My question is whether this is still the case, or that a change has been brought about by the new data protection rules in Finland.
Yeah, I don't remember that specific case, but as a rule, one could say that always after the judgment by the European Court of Human Rights, there are certain measures taken by the national authorities, especially concerning the archiving and the opening of the archive files for the general public. So this must have been the case also in that judgment. And in more general terms, there has been constant analysis and revision of the deadlines for opening files on certain matters, and also concerning the access rights, because there have been in the old times there were several cases of misuse of the access. So there was also one case in the European Court of Human Rights concerning the misuse of access in one local hospital. The nurses were able to access the medical files also of other nurses. But of course, also that procedure was changed afterwards. Thank you.
Thank you. More than a question, I have to do a little intervention. This topic is very important for us, the people who are busy in IT for justice. And I want to express what is needing for us, at least in Italy, because from the one hand, we need very clear rules, very peculiar and very safe for the citizens who are part in the trials. But on the other hand, we need to be transparent to the public and so on. And so the balance between these two main interests, so important for a modern society and for an ICT dominated society, is to be searched with the help of the supervisor, the European supervisor, the national supervisor. And so I want to express the needing for very clear, very simple principles that we can apply without doing the effort every time to analyze the rules and to do our interpretation of them. I can understand that it's a miracle that what I'm asking to the panel, but I have the impression that the more we go toward a European IT justice and the national systems digitalized, the more as possible, the more we need to be very simple, very clear, because it's difficult at the moment, also for our interpreters, for the expert. I have many cases I could tell you, but I don't want, like Aki, don't want to go through national cases that can interest only Italian people, but it is every day more difficult to find this balance out for us operator of the justice field. And so I hope that the new regulation could be a guideline simpler than the directive, than what we had till now. I don't know if you want to comment something about this personal opinion of mine. Thank you.
I hope the regulation can provide an answer to you, but I'm not completely sure about that possibility, because sometimes you have to do this case by case. So it is not possible to find one solution, one fits all, because you have to understand and you know the logic of your processing, of your decision. So the single rule of the regulation would be helpful in terms of implementing principles and have one rule which is the same all over the EU. So this will be helpful from one side, but it is not, from my reading of the text, able to give an answer which data are to be made public, how, and to what extent internet can be, the problem of internet can be solved, because the regulation is technologically neutral and is not able to provide this kind of answers. Maybe in the 2 years, between the adoption of the rules and the putting into force of the provision. There will be space for introducing maybe a clearer rule on the use of some provision, on the effect of some provision. So possibly yes, but I'm not sure that would be a yes, completely yes.
Yeah, I think I could just well, share the same concerns and hopes and concerns. The regulation, of course, it was meant to make things easier, to make everything across Europe is harmonized. It's as you probably know, there's been thousands of amendments in the parliament as a result of all kinds of different lobbying efforts, good and bad, and it's probably if and when it's going to be adopted, it will be more complicated than it would have been ideal. I mean, there will be more exceptions, more just more complex than it should be, but it will still be a regulation, hopefully. And it will still be more harmonized in Europe, which means it's still going to be easier at some level. But it doesn't mean full harmonization, for better or worse. We live in Europe, we have member states, and it's a good thing as well that each country does things in their own way, according to their own culture, especially such important things as transparency, where what an Italian would think about his or her tax data and the publicity of it would be very different from what a Finnish or a Swedish person would think about the same thing. So there has to be room for different things. But I think after the regulation, there will be a little more room, or quite a bit more room, hopefully, for clear all-European advice as well. And it will likely come from two sources. One, the Commission will likely do delegated acts or some sort of implementing rules to the more details on what the regulation cannot tackle at such high levels, so more detailed advice. But also the group of data protection authorities together, they will also continue what they've already done, give more detailed advice. Of course, there's, like everything, the quality could be improved. It could be more clear, the advice there could be, but I think we're already working on it and going in the right direction of giving more practical examples and little, if you've seen any of these recent opinions, there are little examples, practical examples everywhere. For example, if for those interested in transparency versus data protection and how much you publish government information, there was an opinion, I think it was last year, on open data and public sector information. There it's full of examples from different member states, including Italy, for example.
Oh, I don't think it's a rhetorical question that I'm going to ask, but it's in relation to what Ms. Intravaya said just now. Is there any chance that data protection regulation in Europe, from Europe, can quit the, how can I say, tailored dress perspective? Data protection has to relate to cases, single cases. And the framework, to me, it seems that you cannot escape from a case, a logic that starts from the case, the single case. Privacy, data protection, to me, is like a tailored dress, something that expert hands shape around a single question. Maybe the thing is, can we abstract from that, or is not possible? I hope I was clear about it.
Okay, I will try to answer the question. I'm not sure I will succeed, but that's not a good beginning for an answer. I think it's a very philosophical question, but a very important one. If I understood correctly, correct me if I'm not. I understand your question is as goes to the very nature of privacy law and data protection law, and it is indeed a case-by-case law. It's something that is ideally, if we live now in an English common law country, maybe we would all understand it much easier, because then it's in the culture that things are to be done. Law is something, not general rules, but things decided case by case, and then general rules may be developed from cases which are similar, and I think that's the only correct way of probably thinking of privacy law, that it just has to be, hopefully it's not something that requires a very expensive tailor all the time, the lawyers who tailor it, but something that with common sense we all have to just think, everyone who is building an IT system, for example, just has to think carefully, in my particular case, what is the data I can share, whom can it hurt, how do I make sure that it's protected, what can go wrong? And I think we all have to, those who who process personal data, have to learn this skill of being careful with data.
If I may add something, I think that if we come back to the publication and publication into internet, then we don't have tailor-made rules. We have sector-specific rules. That can be that you decided in the e-justice or in other sector, which are the rules. Provided guidance for publication online of archives of newspapers like Repubblica or Corriere della Sera, when they decide that their archives were to be put into internet or made public, that the guarantee is asked to reflect on the effect of such publication in internet. Since, as the decision Google versus Spain has showed, that you publish an old information which is not updated, and then the search engine link the old information with new information about you, and your life can be destroyed. So this decision is not a tailor-made, but is a decision that has to be taken in the sense that transparency is a value, but transparency has to respect the right of individuals. So you can be as transparent as you can without damaging my reputation, my life, the life of my children, etc., etc. So this is the kind of reasoning. Data protection and privacy are not against transparency. It's just a reflection on, do you really need to have all the data in the internet, to have an endless life of the data concerning me, which are not exact, not update, or even false? Maybe not. And if you apply this kind of reasoning, when you decide to go public, in the sense that once we were used to have a publication in the official journal, and the official journal had a certain distribution. Now the official journal is on the internet. So the same information has a totally different impact on the person. So this is the kind of reasoning we may consider to have. It is a question of culture. The way of made information public has changed. Our culture has to be improved in the sense of reflecting on what are we going to put in the internet. And it was referring to a decision which is taken by the Finnish authorities, if I remember correctly. So this kind of reasoning is present in more than we think.
Discussing these issues in the European context, but still we need to remember that the challenges are global. And for example, the cloud computing was mentioned this morning, and I think it's one of the biggest challenges of data protection in the future, because if you find some cheap piece of cloud where you can store all your data, it can be very, very attractive to you. And what happens if even in the public procurement there is some cloud computing which just disappears or moves from one continent to another. There are big challenges, so we shouldn't limit us only to the European context. Thanks.
Yeah, you just mentioned that there's not only a draft for a regulation on the protection of directive, and you mentioned the directive focus proceedings, but between the regulation and the directive. So if you have some difficulties in this area, that's one thing. But I think there will be enough other protecting these new documents. So I think it will be a big task for the European Court, the Court of the European Union, or interpretation of the different documents, especially if you remember that there's a fundamental right of privacy. The Charter of Fundamental Rights of the EU. Do you think that the Court of the European Union will be in the position to interpret for the interpretation of all these problems, or do you think that it must be the Commission or the Parliament, the task of the Commission and Parliament to solve these problems before we all decide about the different drafts of these documents?
Thank you. It's a challenging question. The Italian presidency is trying to solve some of the problems linked to the scope of application of the directive, and in the sense that the directive is now focused on the prevention, contrast, and prosecution of criminal offenses. And there is an area which is not this is the idea of some delegation which is not covered and risk to go and be only reference into the regulation, which is the area of the public order and public security. This area is challenging in the sense that we don't have an European notion of public order in particular. We have a possibility of an European definition of public security. And so the Italian presidency is now working with the idea of introducing public security, the maintenance of public security into the scope of application of the directive in order to clarify and better define the possibility for action in that field. And so at the very end, to help the European Court and the decision you mentioned. Thank you.
I would have had a last question, but as I was warned that we only have 10 minutes for coffee, it's better to conclude our discussion. And thank you very much to the audience for the interesting questions and for being so active. And I thank also everything to our speakers who had an excellent job in answering and in giving the presentations. Thank you.
Ladies and gentlemen, thank you for joining our panel on cross-border evidence. Today we have a few guest speakers that are ready to share with you a part of their professional experience and also to stay in contact with you in order to follow potential collaborative professional networks in the field of cross-border evidence. So starting with this point, I would like to offer the floor to our special leading communicators and to officially declare our session open. Thank you very much. Mrs. Ribeiro.
Thank you very much. I will give a short introduction of myself. So I am a prosecutor. I'm from Portugal. I've worked for some years now in criminal prosecutions in different areas, including cyber criminality. For 2 years now, I am the investigations coordinator in the Office of the Prosecutor of the International Criminal Court. And in that capacity is my role mainly to ensure that all the investigations that are led by the teams have some standards in terms of how they are organized and performed, and also giving some advice, ensuring also the management of the resources, and ensure that we develop the proper investigative strategies for the investigation teams. I'm not sure if you want me to do a presentation now or if it's...
I would say that every leading communicator should follow his or her own presentation, and after that we can follow the questions from the audience. Thank you.
Okay, thank you. So I think I will share with you some of the experiences we have in the Office of the Prosecutor in dealing with the digital evidence. So I can tell you that I worked in the office before from 2004 to 2007. And by that time, I can tell there was no digital evidence, meaning we were investigating the Uganda warlords and the DRC criminal militias, and nobody really had iPads and phones, and there was no digital data. It was all physical evidence and witness evidence. When I came back in 2012, I found a completely different reality. Pretty much everything was happening on the web, and everybody, even in the remote jungle in Africa, have a phone, and sometimes they go back to a village and they connect to the internet and they take photos, and there's a lot of digital evidence going around the world. So I think digital evidence ended by imposing itself. The thing is that we cannot say, oh, I don't want to work with it, because the evidence, I think, both in national jurisdictions and in ours, is in that evidence. So even if we don't like it, we have to live with it. So the office in the beginning had to adjust to this new reality. And we started by having to outsource most of our work with digital evidence. But at some point we realized, because also we thought it would be an unconstant demand from us, but now we realize it's an ongoing issue. So we really created our own cyber investigations capacity. And in that matter, we have 3 cyber experts. We have a little unit that takes care of that. And we are really investing in that area. What I can tell you, and that was one of the things we talked, is how do I, as a prosecutor in a national environment, look at the similarities and the differences between our investigations and the ones we do at the national level. Well, I can tell you that the forensic standards for the collection and the authentication of the digital evidence are very similar. Because why? Our evidence collection is across the globe, so we can collect digital evidence from anywhere, depending where the data or the person owing the data is located. And because we rely on the states for the cooperation, we pretty much have to use all legislations. But what we try is to ensure that the way we forensic deal with the evidence is standardized, and we do it in-house as much as possible. And we do it to what we consider to be the highest forensic standards that you can do it. And we do it by also our forensic experts come from national jurisdictions and network with police, law enforcement, and other entities to ensure that that is the case. Also, I think it's also the fact that we rely on international cooperation for for the collection of this evidence is also something you also knew at the national level. Most of the times you have to ask for the internet service providers for that information. You sometimes have to do a bit of international cooperation. Although the difference is that we always have to do it. That's very rare when we don't have to deal with international cooperation for this type of evidence. Also, we also use the same types of evidence in telecommunications, phones, emails, social media, and the lot. So that was another similarity. And we have to deal, like we do at the national level, with massive amounts of data that comes out of the digital evidence. Whenever we seize an email account, you're talking about 3 or 4 years of email communications, and you have pretty much to filter all of that to get your relevant evidence out of it. That takes resources and time, and is something I think I remember also having to deal with at the national level. The big difference is that although we use the same type of evidence, we also do it in a wider and bigger variety. Our cases are very high profile in terms of the world, so we do a lot of social media exploitation, and there's a lot of video links that relate to the areas under conflict now. So we pretty much do a lot of that exploitation, and my colleague Julian can tell you a little bit more about that. So I think we go beyond what we normally do at the national level, so we explore other types of evidence. And we also do a lot of self-generated digital evidence. I give you an example. If we have a very remote crime scene, as we usually do, where we can get a team there with high costs and requiring a lot of efforts from the host state and potentially military that are located in the region we want to access, we can do it once, meaning it's not that we can send teams constantly to that location. So we invest a lot in doing crime scene examinations to a level that pretty much creates also digital evidence with a reconstruction, virtual reconstruction, for example, of a crime scene. And then we basically present that in the court, and it has its challenges in itself. So we also self-generate some of it. And yeah, so I think, and the ways we collect are also a bit different because we rely a lot in communication, and we don't have authoritative powers. So of course we do search and seizures like a national jurisdiction, but we do it in cooperation with a state. We collect a lot of digital evidence through third parties voluntarily, and non-governmental organizations, companies that work in the areas, witnesses who just provide us things that they collected themselves while they were there firsthand, and they passed it on to us. And I don't want to take more time, so I think I'll pass it on to somebody else. I don't know if you want to comment something.
Do you want to turn that one off, Christina? So do you want to switch? Oh. Yeah. Well, just to follow on from what Christina has to say, because Christina has obviously raised two interrelated points which affect everybody in both the criminal system and also civil systems, and that is the seizing and obtaining of evidence in digital format. First of all, there are two aspects to that. The first part is physically where the evidence might be located. So I'm sure most people in this room are aware that you can just, to give one example of many, you could be investigating a crime where all of the evidence actually is in a separate jurisdiction where the criminal has actually perpetrated the crime, but the victims are in your own jurisdiction. So the question is, how do you obtain that evidence? That's one aspect of it. And for those of you who are not familiar with it, in the criminal context, the Belgian case of Yahoo is highly significant. And I do urge you, if you are a criminal practitioner, to actually have a look at all of the case decisions in the Yahoo case. In this case, there was credit card fraud in Belgium perpetrated by Belgian citizens, and some of the evidence was in emails through Yahoo accounts. And the Belgian prosecutor, instead of asking for an MLA, they asked Yahoo direct. Yahoo refused because it did not have offices in Belgium. For anybody who is familiar with this case, it's now on its 7th judgment, and I'm publishing the 7th judgment next month. And it has finally been agreed by the Supreme Court in Belgium that Yahoo is liable, and they do not accept the argument that because Yahoo does not have an office in Belgium, that they should not be liable directly to the Belgian prosecutor to deliver up evidence. So that is actually quite important. We have a PDF handout that accompanies this session with a link to all of the judgments. I've got the paper version here, not the digital version, but every single judgment has a direct link, so you can download all of the links and read the translations. Now, in association with that, you've also got to ask yourself, is the evidence seized done so in a manner which is acceptable in your own judicial legal system? There has been a case in England and Wales of VAT fraud dealing with mobile telephones in 2004, 2005. In this case, very briefly, the evidence was seized from a bank in the Netherlands by the Dutch financial police. And the Dutch financial police then gave the evidence to the British or the English police. Now, one of the problems with this case is that there are guidelines for seizing evidence in the Netherlands, but it's secret. It is not available to anybody but the police. So if you are a defense lawyer, how do you know that the evidence has been seized in accordance with the guidelines? Because that can affect its authenticity and therefore its admissibility. And so has been tried once with the person in absence. The Court of Appeal said it should never have been tried with the person in absence, so there might be another trial, and this particular issue may be raised. So that does raise a fundamental problem, and I'm sure, I know the International Criminal Court also have this problem. And the other practical thing that Christina has mentioned is the authentication of digital evidence. Now, of all the work I've done, and I've covered 45 jurisdictions in my 2 books on this topic, and that is, there are 2 general pathways to authentication of evidence. In some jurisdictions, and this is not split between common law countries and civil law countries, because common law countries and civil law countries can have the same rules. So, for instance, Germany and America have identical rules regarding authentication. So it's not a split between European and England and Wales, as it were. So some countries require everything to be authenticated before it is accepted into legal proceedings. And some countries also give particular types of evidence an automatic acceptance, which the judge has to accept. And for instance, admissible, and that judge must accept it, unless the person whose signature it is says, no, it is not mine. In England and Wales, it is completely different. In civil proceedings, it is assumed that both parties accept the authenticity of the evidence, and there is no need to prove it, which of course reduces the costs of proof. So there are various mechanisms by which people adopt. And also there is a difference, just to finish off, in a difference between what I call simple electronic evidence and complex electronic evidence. An example of simple electronic evidence would be text messages or emails, or even to a certain extent, social media, whereas complex electronic evidence is evidence of ATM fraud or online banking, where the banking systems are very complex back-end systems. And I have developed a 5-part test which must be looked at to establish the authenticity of that sort of evidence. So we are looking at several issues wrapped in one there, and it would be very interesting, perhaps, Julian, if you could suggest to us in practice what happens in the International Criminal Court.
Well, let me begin. My name is Julian Nichols. I'm a senior trial lawyer at the International Criminal Court. I started there this year. Before that, I was 13 years at the ICTY, the International Criminal Tribunal for the former Yugoslavia. Thank you. Christina's point, which Steve followed on, is that sometimes we're operating in areas that are either current conflict zones, or even if there's not an active armed conflict underway, are very difficult for us to get into and investigate. We can't, what we say, get the boots on the ground, which makes us rely much more on different types of evidence, including digital evidence. And as Steve was saying, sometimes our witnesses, our survivors, and different people we want to interview are also very hard to reach because they may have been ethnically cleansed out of the area where the crime occurred. They may still be in that area and be very difficult to reach. So we try to find all different types of evidence to work with and corroborate the witness testimony that we're able to achieve. And one example is aerial imagery, which was incredibly important in the Srebrenica cases at the ICTY. That is because at the time of these events in July 1995, from the United States, we were able to get images of crowds of prisoners, of Muslim prisoners held by the Bosnian Serb army and police. And we knew the date and the time and the place where those prisoners were held, who were subsequently all executed, except for a handful of people who miraculously survived. In tandem with that, we had aerial imagery of execution and burial sites, usually not of the actual burial, or never of the execution, but of the burials. However, it showed the disturbed earth, because these photos from the overhead imagery, I can't talk about the platform, were taken at a regular time. So you could see on July 5th, this is a normal field in the middle of a small village, and you can see that it's just simple, there are crops growing there. On July 20th, the ground shows signs of disturbance. You can see tractor tracks even from the aerial imagery. And what happens is, why is that important? Because we know from the aerial photo of the crowd of people that was, say, on the 13th of July, 1995. We know from our survivors that they were taken somewhere to a field where 1,200 people were executed. 2 people managed to survive. And we know the approximate area from the survivors before we get this aerial imagery. If we then are able to eventually exhume those sites, and often they were what we call robbed, they were, the perpetrators dug up the bodies and moved them somewhere else. Through that aerial imagery and through the survivor testimony and through the forensics of the DNA, which we were able to identify from the primary secondary graves, we were able to tell when those executions took place and who they were, which is important through the prosecution, because the defense will otherwise be, when a mass grave is discovered, well, you don't know who those people are, you don't know when they were killed, you don't know whether these were combat deaths. So all of that comes together along with another type of evidence we use, which is video. We didn't have so much back then. Now we have much more at the ICC. And we had some user-generated video taken at the same time in the same period, which also helped us put all these pieces of the puzzle together. Now, getting that type of evidence admitted at the ICTY or the ICC, we're a hybrid system. We have judges from civil and common law, but we're essentially, at both ICTY and ICC, we're governed by the statute and the rules, which are lean in admissibility probably more towards the common law system. However, unlike the pure common law system in UK or US, We don't have juries. We have professional judges, as you do here. So there's a fairly pragmatic approach to the introduction of evidence. What is needed to be shown is that you've got prima facie basic reliability, basic authenticity. So you need to call some evidence that would allow a person to conclude that this evidence is what the party calling it says it could be. It's not beyond reasonable doubt at that stage. That's simply for admissibility. So for more advanced types of electronic evidence, including recently in Rudo and Sang case, we've been able to introduce thermal imagery. So that is not photographic, it's measuring temperature spikes from satellites, an area showing the difference in temperature. And you can imagine if you have a timeline of the satellite taking the temperature in these areas, you get spikes on certain dates, very extreme spikes. That will show you there's much more heat generated, and it's quite accurate to the centers. That will then show you, if your case is this is when villages were burned, this is when homes were burned down in post-election violence, it's more proof of that, which will be corroborated by your people on your ground, by your aerial imagery of the burned villages. But that type of evidence, as it would be in a common law system, may need to be introduced through an expert who can explain and authenticate it, because it is a bit novel, and it's not as simple to show that it's got the minimal indicia of reliability and authenticity. Hope that answered your question.
Yes, thank you. I think that the introductory remarks made by my colleagues Christina, Julian, and Stephen kind of help us understand some of the problems that we're looking at today, especially if perhaps we reason a bit by analogy, which is to say, I suspect that nearly everybody in the room is carrying one of these, if not one of those, and at least half of the people in the room don't come from Italy. And we've walked across here, and somehow there's a technical protocol which ensures that our phones are working across borders. And the title of this session is Cross Borders, and what we're trying to focus on is, and you'll understand why I'm coming at it perhaps from a slightly different angle to my colleagues, we're interested in international standard setting, right? And standard setting, in the same way as my phones normally work across borders, for those of you who carry computers with Wi-Fi capability in most locations, except apparently the Italian Corte di Cassazione, they will work. You can hook up to something called Wi-Fi. And Wi-Fi, whether it's 802G or 802N, is calculated to be a standard which is going to work across borders, whichever technology you are using, which perhaps might help you to understand why, together with my colleague Mariangela Biasiotti in the room. Mariangela, please raise your hand so they know who I'm talking about. One of the things we're doing in the evidence project, right? So if you want more information, we have a number of leaflets here which can also point you to our website, etc. The evidence project is actually an EU FP7 supported research project which is intended to explore the ways and means of international standard setting in digital evidence. In the end, there's also the ambition, and ambitious it may be, to come up with a roadmap of the way forward. And frankly, we don't know yet whether the roadmap is going to say there can be a way forward in some things, but not in others. But perhaps it can help to explain to you some of the dimensions we look at, and you'll permit me, if I'm anecdotal for a minute or so, to explain some of the reasons why we're interested in the subject. In wearing one of my hats, I co-direct a research group in the Netherlands, and over there, much of our interest is in security, technology, and e-privacy. And when we look at this from a data protection law point of view. A number of people in the room will have known me to have been working in this field for almost 30 years now. As we saw in the previous session we had today, and also in some of the questions that were asked during the plenary session in the morning, courts, since they deal with people, are also going to deal with personal data, and therefore, almost by definition, we need to sort out the privacy and data protection aspects which are involved. Because many courts around the world have a principle of transparency and a principle of records, which are going to say that Joe Cannataci was on this day found to have been guilty, to be at the inside the Corte di Cassazione in Rome without using an air conditioner. That crime will actually be recorded and will actually be transmitted and maintained in the court record in a way where Joe Cannataci is identifiable. But of course, that's not the only objective. The other objective that we have and the other interest we have from a digital evidence point of view is how you package it, is how you try to do your best to make it interoperable when you're taking the evidence and sending it from one jurisdiction to another. This is something which we are studying inside the Evidence Project, which is the subject of a number of articles, most notably by Stephen Mason, whom we are so fortunate to have here at the table today, where we're trying to examine what are the realistic possibilities as well as the natural impediments to evidence being more easily transferred across borders. Because that it can be transferred across borders, there is no doubt. But will we ever see the day when the standards, when the international standards will permit us to transfer evidence in a way which is easier? Now, we have to remember that when we look at mutual legal assistance, which is the old-fashioned tool we still use in so many of these cases, and going back to 1959, if my memory serves me well, that is a mechanism which has grown out of another multilateral treaty, another convention. So one of the questions we shall be asking ourselves within the Evidence Project is, we're quite sure that another international treaty cannot solve everything, but it may solve something, it may solve some of the things, and we think that we can look forward to some international standard setting in that area. And let me remind you, if I had to put on another hat from the past, apart from data protection, I've also participated for 5 years in the drafting of the Cybercrime Convention. And when we look at the Cybercrime Convention, we can see, and this was an attempt, a strong attempt between countries with vested interests to, for the first time, be in a position to preserve data and then to be able to use it for investigation, detection, and prosecution. Now, the Cybercrime Convention has had a mixed approach. It's the only piece of international law which we have governing cyberspace. So for those of us who are interested in cybercrime and digital evidence linked to cybercrime, the Cybercrime Convention can actually be very useful. When I've been in Washington on a few occasions and I've deliberately asked US prosecutors, I've told them, are you happy with the convention? Is the 24/7 mechanism working for you? Are the mechanisms, the various sections of the convention, 16, 17, 19, etc., designed to help you preserve evidence? Are they working for you? And I was pleased to find out that recently the answers started changing. Whereas in the past, people had been more skeptical, apparently, and this I suggest is an area which merits further investigation, apparently it seems to be working in the area of cybercrime. Which is why I ask myself the question, if we've managed to write an international treaty setting standards in the criminal sector, can't we do the same in the civil sector? And when we were preparing for this session, Stephen and Mariangela made a number of very interesting suggestions in dividing the session, looking at both the criminal and the civil aspect. I would suggest that it would really be interesting if some of us would be able to look at the civil aspect too and see what else could be tackled. But I'll stop here for now, and perhaps we could either open the floor to the audience and then come back to other issues like training and other issues which are of cross-border relevance. Thank you. One at a time, please.
Thank you. What we are saying to us. Just a curiosity, if you ever exchanged digital evidence from ICC to other national courts or vice versa, which were the requirements you were communicating together with the evidence?
Well, that did begin to happen more and more towards the ICTY is now beginning to shut down. It's only got a couple trials left that are running now that the Carritage case just closed its evidence and closing statements. And so much more of the load of prosecuting these cases, because there are a huge amount of cases remaining, are being done by special war crime state courts in Sarajevo and Belgrade and other places. So of course, there is a big issue of in their trials, they need access to our evidence. And in the earlier days, we were looking for evidence from them, including much less sophisticated than what we get now, but things like intercepts and other military communications which they had. And it was basically done, it was a little bit unique because the ICTY was set up under Chapter 7, and states were very willing or felt obliged to cooperate in a way that they don't always with the ICC. And it was done by a formal RFA, or request for information process that we had, but we had the same issues of authenticity back and forth, which everything we received. So again, the main issue with every piece of video, every photo, every recording that we got was to either corroborate it through witness testimony and the totality of the evidence, or if necessary, through expert testimony. I hope that answered your question.
If I can add. So basically, the Rome Statute allows for a mechanism of sharing of information. So when we want evidence collected, for example, in the house of a person who might have interesting evidence, we will do a request, a formal request to a state to support us in a search and seizure operation. We could either request for our forensic experts to be present, or if we actually rely on the competence of the state to do it, we just ask them to do it. But you have to understand, we work with states that have no capacity at all, so that just don't have that type of invest. So but if it's in Europe, pretty much we just ask for them to do a forensic. What evidence we collect, we bring it to our case. But if there is a similar and parallel investigation in the national proceedings, there's of course a space for some sharing of information, as long as, for example, the requested state, that becomes a bit more tricky. If we get evidence in state A to be given to state B, and it comes through us, we get, of course, to have the consent of the other state. And there's also something that we share a lot, which is the security of the witnesses. If the evidence was collected in an area in which the witness will be placed at risk by sharing with another state, then we probably, and we have the possibility of withholding that information. But there are mechanisms that allow us to do that sharing of information.
And sorry, let me just add to that, that's a very important issue, what you said about the witness protection, and that was true at the ICTY. So it was never, there was never an automatic provision of evidence to the state authorities. It was always a very involved procedure to make sure that all the witness protection issues were covered and seeking consent from all the necessary parties.
I mean, another aspect of that is, I mean, I am sort of sympathetic towards Joe's proposition that we move towards some sort of convention if possible. And you're right, I agree with you that it will never be perfect. But clearly the Cybercrime Convention is beginning to work. So clearly that demonstrates that lines of electronic or digital evidence, whichever you like to call it, will be helpful. So when it comes to the authentication again and obtaining it from another jurisdiction and asking about authentication issues, obviously Julian has pointed out that you have other corroborative evidence to support the digital evidence anyway. And what is interesting, not as I mentioned when I asked the Supreme Court judges about the education of lawyers and evidence, you do get some lawyers who ask very silly questions in court and ask for proof of evidence which is not necessary. And their questions are so basic as to be almost laughable. And there are some examples that have been given in the International Criminal Court, which one of the articles that I'm publishing next month will demonstrate. And the judges quite rightly rejected the challenge by the defense because it was such a ridiculous challenge. One example from England and Wales, I'll give you in a criminal context, and that is a man threatened his wife of killing her. And there was lots of evidence other than emails, but one of the items of evidence was an email which he sent to his wife saying he's going to kill her. At the Court of Appeal, when the matter was appealed, one of the points of appeal was the defense arguing that the prosecution had not proven the evidential foundations of the email. And the judges were very quick to point out that that was not necessary, because the issue was how many people in the world knew this woman, 10 or 15. Of those 10 or 15 people, which one wanted to kill her? So that, together with all the other corroborating evidence, demonstrated there was no need to go to the expense of proving for absolute certainty that the email was sent from a particular computer and received by a particular computer. Now, with a convention, the problem, the strength of a convention would be something which courts would apply their minds to. Whereas at the moment, if we just take that other example I mentioned earlier on of the evidence seized in the Netherlands and used in an English court, there's a set of guidelines in the Netherlands which are secret. If an English court is going to deal with them properly, they really ought to know what those guidelines are and have them translated. And then there should be evidence as to whether or not the guidelines were followed. And if they were not followed, why they were not followed, and maybe if they should have been collected in accordance with the guidelines issued by the Association of Chief Police Officers in England, rather than the Dutch ones. So these are obviously complex issues of sovereignty as much as anything, but would be useful, I think, to actually discuss in an international fora.
Yes, and if I can come in slightly on this. Now I would invite you to go to the next stage. Apart from thinking about the very valid points raised by my colleague, think a bit forward as to how you're going to achieve the impossible, which is, I'm of course only joking slightly when I say the impossible, because we do have a challenge, and here I'll share some of the work we're doing at present in another context, which is how on earth do you train digital forensic scientists and lawyers, not to mention judges, in the right way forward, right? In other words, at this moment in time, for you to become a judge, or for you to become a lawyer, or indeed for you to become a chartered information professional in the UK, you have to go through years of exams and this, that, and the other. But what exactly do you need to train and show that you're proficient as a digital forensics person? And I'm choosing my words carefully here, and I'm going to give you an example. At this moment in time, we're trying to put together a master's and indeed PhD programs between 6 universities. Some of us are specialized in digital forensics, others are specialized in technology law, and we're coming from 6 different jurisdictions, including 1 or 2 common law jurisdictions. And yet, at this moment in time, even when we started off with the syllabus that Stephen had very kindly and very usefully put together some time ago, we were still tearing our hair out as to, so what exactly should be the core subjects? And firstly, think about the following. 1, if you have somebody who has got a first degree in computer science, how much law should they do when they come to handle things? And if you have somebody who's done law as a first degree, what should they do in order to be able to train in digital forensics? And it's no joke, you know, because had we more time, I'm sure all of us around the table could spend until tomorrow morning telling you horror stories about some of the devices we've had to look at or present evidence about. And I've literally been involved in one where we found a digital, they were still called PDAs, right? And not even smartphones, but where you had a PDA whose operating system was, obsolete. And the only way we could find an operating manual for this PDA to even start it up properly was to buy an operating system manual on eBay, and we suspect it came from somewhere inside the Russian mafia. Now, if you think that you're going to have problems providing how good your evidence base is there, we could go on, because the number of problems we see in devices, actually grabbing the devices, grabbing the data, especially once again, and I like to finish on privacy and data protection rights perspective. We've had a number of judgments, whether in Malta, whether in other countries, which state, listen guys, today somebody's smartphone is an extension of their personality. You can't, as a police person, simply grab the phone and run away with it. You might have to give it back. You can only keep what is relevant. Anything which is not relevant to your case, how on earth are you going to go around that? What are the correct procedures? Which is why we go back to what Stephen said, by having a piece of international law which makes standards transparent, which makes standards of obtaining and seizing evidence transparent, we could at least go some way towards solving some of the problems.
National law enforcement agencies are almost secret. They're not disclosed at all. No possibility even just asking, okay, but can we just have an idea of which is the procedure that you follow? Now we have some guidelines. That's all.
I don't have that experience, meaning it's an expert evidence. So any forensic expert would have to justify what they use. I can talk from my home experience and the ICC. So when I send a forensic computer to the forensic expert, I'm expecting, and I receive a report in which the person would say, I did a digital imaging using this software. This was the hash number given to the forensic copy. This is the procedures, and they are all pre-disclosable. So it's on the report that is then disclosed to the defense. Of course, that is disclosed to the parties, and it's the same procedure we have at the ICC. And therefore, you know exactly what was done to that piece of evidence. And then we also go further in how have we exploited that. I give you an example. We did search, for example, which is emails are particularly challenging piece of evidence to deal with. I don't know how many of you had to deal with it, because they are massive, they are private, sometimes can have privileged conversations in it, and somebody has to go through them and see what's relevant and what it isn't to destroy and to use in the proceedings. Some jurisdictions require the judge to do that work personally, because they make correlation with correspondence like a mail. So we had to jurisprudence had to decide on that, because it's impossible that a judge can look at thousands of emails one by one. So you have to automate your review processes. And therefore, to answer your question, I think it's not necessarily they are hidden. There are parts of it that are not necessarily, meaning you don't tell how you decrypt a password. But if you do, you might have to explain how you were able to do it, because otherwise there's no transparency. An expert report, being in a report or as a witness, and they have to explain how that was done so that you can show to the judges that the evidence is reliable or it's just not acceptable.
Yes, and I agree with Christina. I mean, actually, how many people in the room have come across encrypted data yet in digital format? Oh, one or two, yes. I mean, there are different mechanisms by which to decrypt if you do not have the password, but some of them will not work because if the key is so big and the password so long, you might take 1,000 years basically to obtain the password. So sometimes you just cannot use that evidence at all. To go back to the point that you raised is that certainly, I mean, for lawyers, things should be open and transparent, and was just rather surprising that I found the Dutch guidelines were not available to anybody other than if you asked for them. And I did manage to get a copy on the strict understanding that I did not distribute it to anybody else on the globe. So it's written in Dutch, so I don't read Dutch, so it's not very useful to me. But it goes back to the point, maybe when we come to thinking about a convention, is that that can link in, first of all, for requesting digital evidence, because clearly at the moment, there are three mechanisms to obtain electronic evidence. Certainly in a criminal context, there's obviously an informal mechanism. So, for instance, the UK has an officer from the Crown Prosecution Service posted to Washington, D.C. for 2 or 3 years to act as a liaison officer to obtain evidence from the USA. And they do that literally informally. Obviously, there's the formal method of MLA, which can be very difficult and time-consuming. And there's the direct evidence by going directly to the provider, as the Belgians have done in the Yahoo case. And those sorts of things ideally ought to be covered in the convention, which I'm sure Joe agrees. There's also one other thing that ought to be included in the convention, and that is blocking statutes. Have we any French colleagues in the room? I don't mean to disparage the French, but they have a very strict blocking statute, which actually has very little rationale for it in most ordinary cases. And there was one prosecution of Christophe X a few years ago. The judgment is fully translated and it's on my website, but he was found guilty, a lawyer found guilty and charged and fined 10,000 euros. So that's also an issue that ought to be addressed. I don't know what your views are on that, Joe.
Well, I'll be very brief because I'm conscious of the fact that we go on too much longer will be accused of obstructing the tour around the building. But in a nutshell, I'm in complete agreement. The issue of blocking statutes, in fact, one of the things that eventually I suspect that Mariangel, myself, and others in the evidence project would set out to do is actually a set of things that you would like to see fixed, right? In fact, this is an open invitation in the room, Christina and Julian yourselves included. Anything which you would like to see fixed as you go around your normal business of exchanging evidence across borders, it would be extremely helpful to us if we could know what that is, identify it, and bring it up for policy consideration. Because in many cases, what we've looked at in all the projects which have been carried out over the past 10, 15 years on digital evidence, the projects spend a lot of time on definitions, on trying to understand this, that, and the other. But then when it comes to concrete solutions, we see much less, also because of the fact, to be fair to all the other projects, that their technology moves on so fast that they didn't even have time to settle down. Talking to other colleagues in the ICC, we have had confirmation that sometimes with the older cases in places in Africa, they could be in one country still dealing with floppy disks, but in another they're dealing with smartphones, and every technology in between, right? Now, for you to handle that, that's a practical issue we have to look at. But the issues which the lawyers best know about, or the police and the law enforcement best know about when it comes to the standards applied and used, those are things which we think could be more susceptible to midterm and long-term legislation at the international level. Thank you.
If I can already do my contribution to that, since we are in here.
She's busy taking notes.
And I'm going to, I think chapters where we have found from our experience that would be really beneficial to have some standardization of practices across the globe would be preservation, meaning it should be standardized, the type of preservation and destruction of materials, so that because the legislation is very different from state to state. Some states just keep it everything, others destroy it after. Europe has kind of a bit of already, but there's a lot of on that. How it is stored and shared with, it's sometimes difficult to get the digital versions of call data records. You just get these printed things that you cannot work with that. And it would be really important that the states would force the service providers to comply with certain sharing mechanisms. I can tell you, we had last year some contacts with international internet service providers, the big ones. And they have a lot of difficulties in looking into this type of mechanisms of controlling their own net. And in particular, when it comes to states. And I also have a point, and I just live here for, there are democratic states and there are non-democratic states. And basically a request coming from some non-democratic states about some data on emails and Facebook, it's actually to arrest and prosecute people that are demonstrating for democracy, for example. So they can be caught in the middle of this dilemma if there's suddenly a law that really forces them for sharing of information. So all of that has to be taken into consideration.
Okay, ladies and gentlemen, thank you for your attention. We really hope that this session has brought into your attention not only the cross-border evidence, but a lot of questions that we are following in solving different cases across borders. And if you would like to find more about these topics, I would like to invite you to stay in contact with us and to follow, hopefully, future similar sessions. Thank you.
So, ladies and gentlemen, we're sharing the tips with the lady over there. Apparently, those of you who are interested in joining the tour to around the building, please make sure you're downstairs in front of the main hall where we were this morning in not less than 4 minutes and 58 seconds. Thank you.